This is Paul. Yes. You know, having lived with my wife at the Guam Airport Hotel, I know what she took with her. Yes. And then I know what I kept as a backup of all my known documentation. Yes. She took the tax returns, Judge Rohr. Pooch. If she did present you 2 years of tax returns, well, we had our taxes done on Guam when we moved there in 2010. Yes. We had our taxes done in Airway Heights at the local library. Yes. And a volunteer did our taxes for us. And I don't remember the exact amount that we got back, but I do know that we did our taxes. And when in 2011, yeah, there was somebody nice enough to help us with our taxes. And Heidi did take the tax returns. So I just wanted to know when I finally get a copy of the dissolution of marriage and I get some sort of knowledge about all this child support that I owe. Yes, in Snohomish County, you're required to have 2 years of federal income tax return. Now, a restraining orders, okay. Where presented, application for temporary restraining orders may be presented ex parte. Motions for relief to be effected during the pendency of litigation shall be noted for hearing. Commissioner's calendar agreed. Restraining orders may be presented ex parte. Now, notice to me as the opponent. If an appearance has been made by a party, notice to the opponent, to the party pro se, must be given prior to application for any immediate temporary restraining order. Now, I didn't get notice of court hearings after she motioned the court for default dissolution of marriage. See, I put approved and void motions to quash, or terminate temporary restraining orders. Shall be noted for hearing on a commissioner's calendar. Now, all immediate temporary restraining orders shall be made mutual where appropriate. Yep. Now, these temporary restraining orders, adverse party has been given prior notice deemed adequate by the court hearing the same. Yeah. I actually wasn't a resident of the state of Washington. Now, the parties have been separated more than 14 days. You know, when your wife abducts your sons, yes, and makes up some lie about domestic violence and child abuse and has you put in jail for 10 days in a Guamanian jail. And then she says, well, I have custody of the children and 90% of the law is custody, as in possession. Really issuing protection orders and dissolution of marriage where you don't give me notice and you don't do what the court rules say. Yeah. This whole idea, well, I have the kids and, well, the other party has voluntarily vacated the family residence for more than 14 days. Have been separated for more than 14 days. We were actually separated, well, I guess until right now. About 7 years, 5 months, and 8 days. Yes. And then such an order is expected to appear personally and give testimony in support of the request. Yeah. I never talked to a commissioner or a judge during the whole dissolution of marriage. Yes. In fact, the only time I get to talk to judges is after I've been arrested for crimes I didn't commit. There seems to be a big fucking problem right now. The only time I get to talk to judges is after you arrest me. Now, agreed or non-contested orders and decrees. Any case in which the respondent has appeared, yes, as in I never appeared pro se or through counsel prior to the entry of the order of default, yes. There's this suggestion that the respondent, yes, should have gotten notice of this motion for default dissolution of marriage. Yeah, it's a suggestion, yes. As in you can give an ex parte emergency motion for. I don't think that you could have that default dissolution of marriage hearing without me actually getting notice of it. Now, this modification of decree by default, yeah, no permanent decree of modification of support, maintenance, visitation, parenting, plan, or custody shall be entered by default unless the adverse party was served with at least 20 days notice of such proceedings. Yes. This modifying, yeah. Does the petitioner have any obligation to keep me informed of what, well, what state she lives in? County? All right. There are certain requirements. The following shall apply to indirect, remedial, or civil contempt proceedings brought under RCW 7.21.030. Warning, failure to appear. The order to show cause shall contain language and personal service unless otherwise authorized by the court. Show cause motion affidavit must be personally served on the responding party. Arrest or other remedies upon failure to appear at the hearing. If the responding party fails to appear and upon showing of proof of service, and if the warning required above is in the order. There seems to be this whole idea. Would you remove your fucking fraud right now?